2 minutes after the hour by my clock. Church hasn't rung yet, but I think we're on time. So I'd like to welcome everyone to the International Water Resources Association webinar on the nexus of law and water, with a highlight on recent developments in the rights of nature and ecocide. We thank everyone here for joining us today. Our panelists include Dr. John Knox, a professor at Wake Forest University in the United States, Dr. Aaron O'Donnell, a fellow at the University of Melbourne in Australia, Sirji Banjbi, founder of the Rights of Rivers South Asia Alliance in India, Mohammed Aziz, chairman of the River and Delta Research Center in Bangladesh, and Guillermo Prati, a PhD student at the Santa Ana School of Advanced Studies in Pisa, Italy. We're moderated today by Dr. Amish Pandey, an assistant professor of law in Gujarat Maritime University in India. So now, as you probably know, this is a webinar hosted by the International Water Resources Association, and the IWRA is an international network of researchers and practitioners who work on a multidisciplinary range of water resource issues. We provide a global knowledge-based forum for bridging disciplines and geographies by connecting professionals, students, individuals, corporations, and institutions who are all concerned with the sustainable use of the world's water resources. So this webinar today is organized by the IWRA's Water Security Task Force. We have a number of task forces, and if you're interested, you should look on our website, www.iwra.com, and look at joining the task force, because they're a really great way for people from different parts of the world, different backgrounds, to join together on common issues and to host events such as this webinar. So we're going to today address the developments and influences of the right to a healthy environment, and how its definitions have been defined in ecocide, and the influences these have had on each other, and what this might entail for our future, both from a legal viewpoint and from an environmental viewpoint. So our panel will consider the drivers for what has kind of brought this forward in the last few decades, and then provide us a clearer understanding of what this might mean, an impact for rivers, mountains, forests in general. So I think a lot of you have probably already been to our webinars before, but let me just briefly explain the format of today's event. So to start, each of our panelists will give a short presentation, and then we're going to have a time at the end of the event for questions from our audience. So if you have a question you'd like to ask for either the single panelist or in the group, please just go ahead and send it into the Q&A box. Now, I've asked our panelists to keep an eye on that. So if there's anything they can answer quickly for you, they'll just try to get a response. And we'll have the questions and answers there at the end. You should see the question box at the bottom of your Zoom panel, I believe. And of course, if you have any introductions of yourself or otherwise, feel free to put it in the chat box. We like to see our audience have nice interaction with each other, even though we can't all be together in person. It's nice to be able to see people be able to interact a little bit, even virtually. So with that all in mind, I'd like to turn the floor over to our moderator, Dr. Pandey. Dr. Pandey?
Thank you, Scott. Thank you so much. I welcome everyone for being here today, and thank you so much for accepting our invitation. I'll just briefly introduce what Water Security Task Force is about in IWRA. So IWRA does many kinds of work based on water issues, and it has water professionals from all over the world. And at the moment, we have 6 task force, and these task force are dedicated to specific objects. So we have a smart water management, we have water quality, water security, water and climate change, young career and early career and young professional, and groundwater. Today's webinar is brought to you by Water Security Task Force platform of IWRA. Water Security Task Force was informed to position and guide IWRA in discussions on water security. The Water Security Bureau governs and leads the IWRA Water Security Task Force to identify topics of interest from IWRA membership at the interface of science and policy, to work in an interdisciplinary manner to better understand the issues and try to devise some solutions to it. So this is about IWRA. I am a member of IWRA and Water Security Task Force. Without wasting another second, I would like to invite Professor Knox to please start your presentation. Today he will be talking about evolution of environmental rights. Welcome, sir. Please, the floor is yours.
Okay, thank you very much. Thank you for having me here, and it's a pleasure to be here with everyone. So, as Amrisha said, I'm going to talk today about the human rights, the connection between human rights and the environment. I'm going to talk about three issues in particular. The first is, does human rights law, international human rights law, require protection of nature? That is, are there human rights to nature? Second, does nature have rights of its own that are recognized in legal systems? That are there rights of nature in addition to rights to nature? And then third, I'm going to briefly talk about whether environmental destruction may be an international crime. That is there a crime of ecocide? So let me go through these questions one by one. The first one, again, is, are there rights to nature? Does human rights law require that states provide environmental protection? Human rights can apply to the environment in legal form in two main ways. One is that legal systems can recognize a human right to a healthy environment. And the second is that they can apply other human rights, such as rights to life and health, to the environment. At the first approach, that is the recognition of an international human right to a healthy environment, has never been adopted universally at a global level. The 1948 Universal Declaration of Human Rights, which is kind of the foundation of international human rights law, does not include a right to a healthy environment. This is not surprising. In 1948, people really weren't thinking about environmental harm as a major threat to human rights. But even in more recent years, more recent decades, the United Nations has still never recognized formally a human right to a healthy environment. It came pretty close in 1972 at the Stockholm Convention, the first major international environmental convention or conference. The Stockholm Declaration, adopted at that conference, does say that people have the fundamental right to freedom, equality, and adequate conditions of life in an environment of equality that permits a life of dignity and well-being, which sounds pretty close to saying that they have a human right to a healthy environment. But they've never come that close again in the last 50 years. In the Rio Declaration in 1992, for example, they did not repeat that language. However, despite this absence of a overarching, internationally, universally accepted human right to a healthy environment, most countries in the world have accepted that right. Over 100 countries have accepted it through amending their national constitutions, and many more countries, amounting in all to nearly 160, have adopted it either through national legislation or through judicial interpretation of existing rights or through regional treaties. So when you add all of this up together, as I said, you get something like 155 countries around the world, at least, that have accepted in one form or another the idea of a human right to a healthy environment. So that's one approach, that is just write it into human rights law directly. However, another approach, which is actually quite popular, quite widely used, is to interpret other human rights to apply to the environment. That is essentially to green other human rights. Especially in the last 25 years, this has become increasingly important at the international level. The European Court of Human Rights, for example, has interpreted the right to life and the right to private and family life to apply to environmental harm. The African Commission and African Court of Human and People's Rights have interpreted the right to health and rights of indigenous peoples to include environmental components. And I could go on and on. There are many international and both at the United Nations level and the regional level, there are many international tribunals, committees, special rapporteurs who have all applied a very wide variety of rights to environmental harm. Generally, this approach recognizes that environmental harm interferes with the full enjoyment of human rights, and therefore states have obligations to protect against that harm. Now, my role in this, let's say, increased in 2012 when the United Nations Human Rights Council created a new mandate on human rights and the environment and appointed me to be the first holder of the mandate. In particular, they asked me to study the human rights obligations relating to the enjoyment of a safe, clean, healthy, and sustainable environment, and to prepare reports, essentially what that relationship was. So over the next 6 years, between 2012 and 2018, I prepared a lot of reports, a whole series of reports on the relationship between human rights and the environment. And that culminated in 2018 when I presented framework principles on human rights and the environment. These framework principles tried to sum up what international human rights law says about the environment. And there's 16 of them, I won't go through all of them, but they fall into 3 major categories. States have procedural obligations, that is, they have obligations to protect and ensure that people have the right of access to environmental information, to participate in environmental decision making, and to have rights to effective remedies for environmental harm. They also have substantive obligations. Now, no one expects Germany and Madagascar to have exactly the same environmental standards. They're at different stages of economic development. They have different priorities and so forth. However, their standards do share certain requirements. That is, they have to be non-discriminatory. They should be non-retrogressive. That is, they shouldn't fall backwards. And they should be effectively enforced. Once you write your environmental standards into your laws, you should effectively enforce them. A third category of obligations is that states should never discriminate in any way between different groups with respect to environmental protection, but they should also take additional steps to protect those most at risk, who could include women, children, disabled persons, older persons, persons living in poverty. And in particular, in the environmental context, one group that's especially at risk in many contexts are indigenous peoples and traditional communities that are often directly affected by the loss of nature. So that's a very broad overview of what human rights law has to say about the environment. What does it say about biodiversity in particular? Well, in some ways, it's quite specific. That is, the loss of nature, the loss of biological diversity can absolutely interfere with the enjoyment of a very wide range of rights. Again, that's often most clear with respect to indigenous peoples and traditional communities that depend directly on natural ecosystems. But all of us, we're all indigenous to this planet. All of us depend on nature for a very wide range of, the components of a dignified and healthy life. That is, so our rights to food, our rights to health, our rights to life itself are all dependent on a healthy ecosystem. I could go into a lot more detail about that, but I'll just leave it at that for now. So as a result, states do have obligations to protect the rights, not only of indigenous peoples and traditional communities, but also of all of us to protect our rights with respect to a healthy natural ecosystem. Now, how about the second question, rights of nature? Increasingly at the state level, states are starting to write into their laws or having courts interpret their laws in a way that result in rights of nature. An early kind of example of this is the Constitution of the Republic of Ecuador, which in 2008 amended its constitution to provide not only that people have the right to benefit from the environment, but also that nature itself, or Pachamama, has the right to respect for its existence, and that the state has an obligation to apply preventive and restrictive measures on activities that might lead to the destruction of ecosystem and the extinction of species. There are other states that have taken similar actions. Bolivia, for example. New Zealand, a few years ago, agreed that the government of New Zealand agreed with the Maori people and indigenous people in New Zealand to give the Wanganui River ecosystem essentially legal personhood, that is, recognition as a legal person with rights under New Zealand law. Now, the question that always arises here is, well, who actually speaks for the river? How do we know what the river wants? In that situation, the government of New Zealand and the Maori people, the iwi, the people of the Maori most connected to the river, actually agreed on a deed of settlement in which they set out who speaks for the river. 2 people are appointed from nominations by the Maori and the government of New Zealand to, quote, act as the human face of Te Awa Tapua, the Maori name for the riverine ecosystem. And their role is to speak and act on behalf of the river, uphold its legal status, and protect its health and well-being. Now, you're going to hear, I imagine, more about this from another speaker, but an Indian court a few years ago reached a similar decision and cited the Wanganui River settlement as an example of this. And the decision was to give the Ganges and Yamuna rivers, the entire river ecosystem, the same legal rights again as legal persons, as human beings, to be able to hold rights. My understanding, and I'll learn, I expect more about this, but my understanding is that the Supreme Court actually stayed that decision not long after it was issued. So I'm not sure of its effect now in India. But the point is that there is this move towards granting components of nature legal rights. But I want to be clear about this. This is not nearly as well developed. It's not nearly as far along, especially at the international level, as the application of international human rights held by humans, that is, to nature. And then the third question, which I'll just briefly mention, is the definition of the term ecocide. So under the principles of international criminal law, which are set out in the Rome Statute that created the International Criminal Court, there are 4 international crimes over which the court has jurisdiction. And again, I could say a lot more about all of that, but I won't. Just very briefly, those 4 crimes are genocide, crimes against humanity, war crimes, and the crime of aggression. So it has been suggested for some time that a 5th crime should be added, the crime of ecocide. And just this summer, summer in the Northern Hemisphere, just a couple of months ago, an independent expert panel provided a report that defined what this crime of ecocide might look like. They defined ecocide as unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment caused by those acts. In other words, if you're committing unlawful or wanton acts that cause severe or widespread damage to the environment, and you know that's what you're doing, then under this definition, you would be liable for the crime of ecocide. Now, I want to be clear about this. This was a non-governmental organization that came up with this definition. It has in itself no legal effect. What would have to happen for it to have legal effect? The Rome Statute, again, that created the International Criminal Court and gives it jurisdiction, that would have to be amended. Can it be amended? Sure, but it is not an easy process. For amendment to occur, first 2/3 of the state's parties would have to agree. And then a second step would be that it enters into force only after it's been ratified by 7/8 of all the parties. I don't think anyone expects that to happen anytime soon. So there is another approach, which has also been proposed and is apparently now being at least considered by the International Criminal Court. That is to take the existing crime of the crime against humanity, which can include, for example, mass murder, massive abuses of human rights, and apply that in the environmental context. 5 years ago now, in 2016, the Office of the Prosecutor issued a policy statement saying that one of the factors it would take into account in deciding which crimes to prosecute were whether those crimes resulted in destruction of the environment, the illegal exploitation of natural resources, or the illegal dispossession of land. A couple of NGOs filed on behalf of victims of human rights abuses in Cambodia. They filed a case with the ICC, the International Criminal Court, essentially arguing that it was exactly what was occurring in Cambodia as a result of land grabbing. But to my knowledge, the ICC prosecutor has taken no action on that. Nevertheless, I think that may be a more, let's say, realistic short-term approach to applying international criminal law to environmental harm. But I want to be clear about that. Whether or not ecocide is prosecuted now or in the future, it doesn't change the fact that states do have obligations under both international human rights law and in many countries under domestic law, domestic constitutional law, to safeguard the environment in order to protect human rights, and in some countries increasingly to safeguard the environment to protect its own rights. So that concludes my remarks. Thanks again for inviting me, and I'm looking forward to the rest of the conversation.
Thank you, sir. That was a lovely talk. And thanks for explaining the components of right to environment, right to health, right to nature, and how it connects with each other or how it differentiates with one another, and clarifying what ecocide is, how it is not the law yet, and every other thing. To the participants today and all the people who are looking or seeing this webinar now or might see this later by accessing the recording. Nobody needs an introduction for Professor Knox, but for your advantage, I will still give a brief bio after the presentation. So Professor Knox is internationally recognized expert on human rights law and international environmental law. From 2012 to 15, he served as the United Nations first independent expert, as its first special reporter on the issue of human rights obligation relating to the enjoyment of a safe, clean, healthy, and sustainable environment. In that role, he submitted a series of reports, the one which he was referring to in this presentation, those reports to the United Nations Human Rights Council on the application of human rights law to environmental issues, including climate change and the conservation of biological diversity. In 2018, he concluded his mandate by presenting framework principles on human rights and the environment to the United Nations, and by calling upon the United Nations General Assembly to recognize the human rights to a healthy and sustainable environment. We are all looking forward to the recognition of this right as a human right in future yet to come. And with that, thank you so much, sir. We will be moving to our second speaker, which is Dr. Erin O'Donnell, who is joining us today from Australia. A brief bio for ma'am for our participants is, Dr. Erin O'Donnell is a water law and policy expert focusing on water markets, environmental flows, and water governance. She has worked in water management since 2002 in both the private and public sectors. She is recognized internationally for her research into the groundbreaking new field of legal rights for rivers and the challenges and opportunities these new rights create for protecting the multiple social, cultural, and natural values of rivers. In 2018, she was appointed to the inaugural Bairang Council. I'm sorry if I'm pronouncing it wrong. The voice of the Yarra River. For the last 3 years, she has been working in partnership with traditional owners across Victoria to identify law and policy pathways to increase Aboriginal access to water. And she's one of my favorite authors. Thank you so much, ma'am, for joining us today. The floor is all yours.
Thank you so much, Amrisha, and thank you everyone for having me here today. Now I'm going to try and share my screen, so just bear with me while I bring this up. I am going to be talking about, I guess, expanding really on some of the ideas that John has already discussed with us. Let me just see if I can make that, yes, come up properly. So hopefully that's coming through for you all. I'm going to be talking about what happens. Oh, great, thank you. So I'm going to be talking about what happens when a river becomes a person, and we're talking about quite a specific shift in the legal definition and the legal status of rivers. And so John really laid the groundwork for this in his opening remarks around recognizing that nature itself can now have legal rights. So the rights are of nature, they're owned by nature, they belong to nature. So this is quite a departure from the usual treatment of nature as an object over which human beings have absolute dominion. We've typically treated nature, certainly in Western legal frameworks, as though it is property, as though it has no rights or interests of its own, and it is for humans to use as we wish. And we've increasingly placed limitations on humans' ability to use nature and to use the world around us, but we've primarily thought about those limitations for our benefit, right? We don't want to pollute the water that we drink, so we place limits on our ability to do that polluting. Now we're starting to think about, well, actually recognizing the rights of nature, the interests of nature in being able to thrive are actually almost as important, perhaps as important, maybe even more important than our own rights to use the world around us. So this has really profound implications for our relationship to the world around us. And that's what I'd like to talk to today. I'm going to speak to it particularly in the context of rivers and in the nexus of environmental law and water law. So how are we actually translating these new rights and legal powers of rivers into our water law and management frameworks? So to begin, I'm going to focus back in on the river that I know best. So as Amrisha said, I am a member of the Birrarung Council, and this is the Birrarung. The Birrarung is the Woiwurrung name of the Yarra River that flows through the city of Melbourne, which is the capital city of Victoria. The river flows through the country of the Wurundjeri Woiwurrung people, who are the traditional owners of that land. And I would like to also pay my respects to their elders past and present and acknowledge that they have never ceded their rights to lands and waters. So for those of you who don't know, Australia does not have any treaties with Indigenous peoples in Australia. When settler colonists arrived in Australia, they just assumed the land was empty, despite all of the evidence to the contrary. So we have a lot of work to do to fix a fairly fundamental illegitimacy at the heart of Australia. Part of that is through working in partnership and recognising the sovereignty of traditional owners and Indigenous peoples across Australia. So the Birrarung was the first river to be recognised in Australia as a living entity. And the Birrarung Council, of which I'm a member, is the voice of the river. And it is our job to advocate for the protection of the river. This scene comes from the very first time traditional owners, Indigenous peoples, were speaking on the floor of Parliament. This was the passage of the Yarra River Protection Willip-Gin Birrarung Moron Act, which was also Victoria's first ever bilingual legislation. And the name in Woiwurrung, Willip-Gin Birrarung Moron, translates to keep the Birrarung alive. So again, it's this recognition of the river as a living entity that we need to actively work to protect, to keep alive. And the recognition that the river requires us to do this, that we have an obligation to the river to uphold its life. The Yarra sits in this global context of an increasingly large number of rivers around the world that are being recognised as living entities and or legal persons. And I'll talk a little bit in a second about what some of those differences might be. But really since 2017, which was the same year the Yarra was recognised, we've seen rivers around the world gain this extraordinary change in status. They've shifted away from being objects over which we have dominion into being legal persons, legal subjects, entities with rights of their own. And that changes our relationship. Instead of us having dominion over them, we are now in a relationship with them. They are beings that we must coexist with. So as John mentioned, the Wanganui River in Aotearoa, New Zealand, was the first one to really hit the headlines in 2017. The Rio Atrato in Colombia is another really interesting example, because in that case, it was the rights of Indigenous people that really drove the court to recognise and acknowledge the rights of the river itself. So in this case, the Constitutional Court decided that the best way to protect the rights and interests of Indigenous peoples in that region was to acknowledge the biocultural rights of the river. And so again, we see that really close connection between the rights of rivers, the rights of nature, and a protection of the rights of human beings. The Gunja and Yamuna rivers is obviously another really headline example. This one has been stayed by the Supreme Court. We're still waiting on a final ruling, but there are some really interesting things that happened in between. Between the court ruling, this was a state high court in Uttarakhand, and before the decision was stayed. And that just really means paused. So the river's gained legal status. They've almost lost it again. They've kind of entered into this this sort of liminal zone where they are both legal persons and not legal persons at the same time until we hear the results of this appeal. We've also seen rivers, as I've said, in Australia, in Bangladesh, in Mexico, and in the USA receive this kind of status. So it's a global phenomenon. But as I also said, the rivers are being recognised in a range of different ways, and they have very different legal implications. So if we start at the top there and say, well, maybe the first point is this legal person definition. What is a legal person? A legal person in the eyes of the law is basically, it's the subject of the law. In common law countries, it's a personification. It's a way of bundling up all of those rights and powers that we associate with a person and saying this entity has legal status. So a really good example is a corporation. So a corporation doesn't necessarily have human rights, and a legal person doesn't necessarily have human rights, but they do have legal rights. And that typically includes things like the right to go to court, so you can sue. You can also be sued. The right to enter into and enforce contracts, and the right to own property. So these are really quite legalistic rights, but they're fundamental and important in, again, that sort of Western legal framework. Those are the basis of a lot of legal powers. When we move down this list, the next example here, which is very similar to the legal person, is the subject of rights. And we see this in civil law jurisdictions. So for instance, the Colombian case that we'll talk a little bit more about in a second is an example of this kind of right. And what that means is that the rights are enumerated. So the court has to actually spell out which rights go along with that legal subject. So that's what makes it a little bit different to the legal person. The legal person, there's an assumption that a certain amount of rights goes with it. The subject of rights, the court has to spell it out, and it can be very explicit about which rights are included and which rights are not included. And it's the not included which is also very important. And then we have this concept of a living person. And this is terminology that a lot of the Indian cases have used, recognizing rivers and other parts of nature as living persons. So to put that into context, the only recognized living person in law is a human being. So this really started to conflate the idea that rivers and other natural entities were the same in the eyes of the law as human beings. So as you can imagine, that can create some challenging circumstances. The Yamuna River, for instance, an activist filed a police report to say that the Yamuna River had been murdered because it was too toxic to be alive, and if it was a living person and it was no longer alive, then somebody must have killed it. So you can start to see that we can get into some uncomfortable legal territory quite quickly. And then finally at the bottom, we have this idea of a living being or a living entity. This is an idea that does not necessarily bring legal rights. So the Birrarung, the Yarra River, is a living being, but it's not a legal person. So the Birrarung can't go to court on its own, it can't own property. As a voice of the river, I can't necessarily go to court on its behalf, although there's a whole other set of standing law that we'll just probably not talk about tonight because that's too complicated. So the living being is a way of saying what's most important is recognising the status of the river as alive and our relationship with it. If it's alive, we can have a relationship with it, and it's the relationship that then becomes really important. When you focus on the really legal side of things, that's important when it comes to enforcement, but it also can trap you into this really adversarial relationship. So legal personhood can focus you on, can I go to court? A living being says, how do I keep you alive? So when we look around the world, we can see that these ideas are applied often in combination. So as I mentioned before, the Rio Trato is a really great example of the subject of rights. So it's an entidad sujeto de derechos. And I'm going to apologize to any Spanish speakers for my atrocious pronunciation. The court in that case really listed out those very specific rights: protection, conservation, maintenance, and restoration. So again, it said it has to only have these rights. You'll note that it doesn't include the right to go to court. It doesn't include the right to own property. So it doesn't have any property rights. And we'll come back to that in a second. The Wanganui River is a combination. So it's recognised as a living whole, so a living entity, as well as a legal person with all of those rights and duties. As we mentioned, Ganga and Yamuna are a bit of everything. The judges in that case covered all their bases. The Turag and all of the Bangladesh rivers are legal persons and living entities. So again, we have that combination of legal power and that relationship focus. In Australia, we have two rivers at the moment, one recognised in state law, and that's the Birrarung as a living entity. The other is the Murrawarra Fitzroy River, which is recognised in the law of the traditional owners of the river, the Indigenous peoples of the river, as being a living ancestral being. So again, it's a living being. It doesn't necessarily bring it the right to go to court, and that legal status has not been recognised by the state in Australia. So we've got a little bit of legal tension that's unresolved in that case. I'm going to talk very quickly about the guardians because I think this is a bigger conversation that we can probably have, but I'm happy to go into it in questions. The guardians, I think, are a really interesting kind of solution to this problem of how do we know what the river needs. And in all cases, they're an interpretation by the legislature or the courts about who is best placed to understand and to know and to be able to speak for the river. and to be able to actually facilitate communication between the river and other people outside of that circle. So sometimes that's government entities. So in Bangladesh, we have the National River Protection Commission. In other cases, it's the people who know and love the river best. So in the Rio Trato, for instance, it's one man and one woman from the 7 main villages along the river, in addition to a government representative from the Ministry for Environment. So this relationship element emerges really strongly in those guardianship arrangements. Now we get into the water law nexus. And what my research shows is that although the rights are flowing for rivers, the rights to water are not flowing with those rights in law. So we're changing the legal status of rivers, but we're not connecting that change in environmental law into our water law and water management arrangements. So if we look again around the world at those examples, none of the rivers that have received rights or received this changed status in law to be recognised as a legal person or a subject of rights, none of them have rights to water. Some of them are starting to include things like the right to flow, and that's a step, but without a connection into the water law frameworks, then it's really, really difficult to see how that right to flow is going to be interpreted and enforced in any meaningful way. So a good example of that instance might be the Magpie River in Canada that just happened, I think, this year, maybe last year. So we're starting to see people start to think about this, but we're not seeing it actually translate into those water law frameworks. What is a river without water? And I think that's the question that we're now confronting with these rivers that are recognised as legal and living beings, but who have no rights to the water flowing between their banks. A similar situation applies when we think about a role in water management. Water rights are not the only thing, they're not the only way to control water flowing down a river. Water management frameworks and having decision-making power in those water management frameworks can be also really important. But again, we're seeing extremely limited, if any, role for these new guardians and these new rivers, these new river persons in the way that water is being managed. So again, you can sort of see the list of those same rivers. There might be some new institutions to support the guardians, but they have very limited translation into the water and catchment management. Particularly in the case of the Wanganui River, where it says very explicitly in the legislation that nothing in that legislation will affect rights to water or the ongoing management of water. So again, we're seeing this real struggle to connect these new river persons into these water law and management frameworks. And that's a big problem when it comes to enforcement and giving force and effect to the recognition of these river persons. So to finish up from me, some messages that I guess I'd like to probably leave you with when we think about rivers as legal or living persons. Firstly, there's a wide range of legal definitions. So getting the language right and knowing exactly what kind of legal status a river needs or what kind of legal status you're trying to create for a river is really important. It can be potentially transformative. When it works well, what you can do is really strengthen the relationship between people and the rivers. You can shift the conversation from what do we want from the river, which is that really extractive resource management mode, into a conversation where we start asking, what do we want for the river? And then when we recognise the river as being alive, we go further and say, how do we get there with the river? And the river itself can become a collaborator in its own management. That is a profound transition. If we get it wrong, if we emphasise the adversarial relationship over any of the other aspects of the relationship, then you can very quickly go backwards. And we've seen cases around the world where rivers and lakes gain rights and then lose them immediately because those rights are challenged in court and the challenge falls down. We've seen this repeatedly in the US, for instance, the most recent example being Lake Erie. So if we get it wrong, it has the ability to actually take us back further and people lose their willingness to protect rivers in the first place. So it's a bit of a high risk, high reward strategy. And of course, without rights to water and a clear role in water management frameworks, we're actually still selling rivers short. So we need to get all of these elements lined up to really create the kind of sustained change and the sustained relationship that we want with our rivers. And I'll stop sharing and hand back over to Amrisha.
Thank you, ma'am. Thank you for the fascinating presentation. And thank you for clarifying how these rights are construed in different domain and different jurisdiction. How do we interpret them, and what is the state of implementation? I can see that we are trying to address a very new set of problem using the conventional legal setup. That legal setup itself is not evolving. It looks like that itself is a problem. And the point which you brought forward, I think that was troubling many of us, that we are talking about right for nature, right for river, but right to water for river is still something not thought of. And how do we go ahead from there? So thank you so much for this. I invite everyone to please put your questions in Q&A box or the chat box. We will take it after the presentation of all the panelists. Thank you, ma'am. So now from this point, we will be moving to Ms. Shrishti Bajpayee. So I'll give a quick introduction for Shrishti, and she will be taking the floor over. Thank you. Shrishti Bajpayee joined Kalpuresh in 2016. Her research focuses on documenting, researching, and networking on radical alternatives to dominant systems, with a specific focus on exploring indigenous, traditional, and customary ways of living, decision-making, and their underlying worldviews. She helps in coordinating the Vikalp Sangam process. Vikalp in Hindi means alternative for non-Hindi speakers. So Vikalp Sangam process, Sangam is getting things together. So Vikalp Sangam process, and is a core team member of Global Tapestry of Alternatives. She has been researching and networking on the Rights of Nature movement with a specific focus on South Asia. She has helped found Rights of Nature South Asia Alliance. Shrishti has a master's in development studies. Apart from this, she is interested in birds, walks to unknown places, discovering music, and almonds. Very interesting. The floor is all yours, Shrishti. Please go ahead. Unmute yourself, and if you like, you can share your presentation with us.
Thanks, Amrisha. And I will be speaking to you from two screens, so apologies for that. And I hope the presentation will make up for it. You can see it right now?
Yes, it's perfect.
Yes, looks good.
Thank you. So first of all, thank you to Dr. Knox and O'Donnell for doing that presentation and setting the appropriate background for this conversation, which I will be focusing primarily on rights of nature in South Asian context and what beyond that. So I'll get into the beyond aspect later into the conversation, or while exploring what it means for India with specific judgments that are already been mentioned in both the presentations, and what opportunities and challenges it has opened up for many networks and people who have been working on these issues for a long time. So setting the context, I think many of you who are part of this group are in more or less in this context anyway, for why we need rights of nature, but setting it specifically for a South Asian or more or less India level context is that our ecological crises are demanding us to fundamentally rethink our dominant systems, be it legal, but also political, economic, social structures. And many or much of the laws and policies that are currently there are used as means to sanction environmental destruction rather than actually protecting it. And a lot of these are then demanding us to shift from an extractive, colonial, property-oriented mindset of looking at the rest of nature to one where nature rights are recognized, but also rooting itself in many indigenous and nature-dependent communities, cosmologies, and worldviews, which have been speaking about reciprocity, interdependence, and a very relational relationship with the rest of nature. As that picture shows in the top left, that humans are part of nature. So much of what we've been taught is that we are at the dominant position, but a lot of communities have been practicing this as a web of life, something that is interconnected and part of our, that we are as much part of the nature as nature also is alive. Just to set the context of rivers, because that's what the Indian judgment focused on. that the crisis of rivers in India is wide ranging with pollution, damming and diversions already there and proposed, river interlinking projects, sand mining, privatization of rivers, a lot of conflicts between the neighboring countries. So like India and Nepal fighting over a sharing of waters around Kali River, India, Bangladesh, India, China, all of these have had these conflicts of sharing of waters. Climate change and encroachments is the reality that, of course, all of us are aware. With the Indian context, specifically inequalities in the society, which determines the access or not access to the rivers, is also one of the important crises and also the context that determines eventually the rights of the rivers. So now getting into the judgments. So as it was mentioned in the in 2017, the Uttarakhand High Court, which is one of the North Indian states in India, gave rights to rivers Ganga and Yamuna, also their glaciers, that is where they originate from, their rivulets, all the catchment areas, forests around them, having rights to that of a legal person with all corresponding rights and duties of a living person. Something that is a bit of a contention in among many groups who see it as a potential danger, which I'll expand on it later. At the current status, as Dr. Knox was saying, is at stay in the Supreme Court of India, because the Uttarakhand state government went to the Supreme Court saying that this judgment is completely crazy. We cannot implement something like this with no idea of how do we implement it. There are so many states where this river runs through. How do you expect us to implement something like this? So the Supreme Court of India put a stay on the judgment to specify what does a stay means and what does and why it's actually a potential for us. Stay means that the court did not reject the judgment. So anybody who's interested could go to the Supreme Court of India, petitioning it, saying that these are some of the solutions that we would like to offer to the concerns that the Uttarakhand state government raised, and the court will hear your case again, possibly. So that is why stay is a potential at the moment. Apart from this judgment, there were also other judgments that were passed subsequently. In 2018, the same High Court, that is the Uttarakhand High Court, ruled that the entire animal kingdom has rights as that of a living person. And last year, the Punjab and Haryana High Court, which is a neighboring state, declared an order which recognized the rights of Sukhna Lake in the city of Chandigarh. So although rivers got a lot of sort of publicity, because also there was a lot that was happening internationally, these were also the two things that subsequently happened. And in fact, none of these were approached by respective state governments as well. There's also processes happening in neighboring countries, which I'm sure the other panelists will talk in much detail about, which is the Turag River getting rights in Bangladesh, and similar attempts being made in Nepal about thinking around giving rights to Mount Everest, or in Pakistan giving rights to River Indus. So I will be focusing more on what this judgment was about, what impacts and questions and opportunities and challenges it raised, and what it offers as a way forward. Some of the criticism of the judgments are what is a river and what all constitutes a river was never defined in the judgment. This has been a process. India has a water policy, but it doesn't have a river policy. What is a river has never been in a discourse of understanding rivers at all. What does it mean for a river and its associated natural elements, which is also the species in it, the forest, the catchment area, the basin, or the communities living along the river? What does it mean for them to have these rights? It doesn't get into it, doesn't specify all of that. The legal personhood is the tool that currently the court use, but is that the right tool? Specifically, say for example, the Ganga, many communities might not even see Ganga as a person. She's a goddess. So using a tool like legal personhood for a river that is much more beyond a person is of course something that we need to think about. And what then other options within this legal system exist? How will such rights be implemented? These are cross-boundary rivers. There are no institutional mechanisms to recognize these rights. court doesn't get into those nitty-gritties of how do we implement it. It says that so appoints the chief secretary of the Uttarakhand state as one of the most important guardians, but doesn't really look into the role of local communities, and very arbitrarily says that some experts will also be part of this guardianship. How will they do it? What will be the rights? What will be the duties? Nothing on exploring that. And one thing that is very important is that all these rivers actually flow through not just national boundaries or cross through national boundaries, but also international boundaries. So what does it mean to give rights to Ganga in India, but what does it mean for Bangladesh? And what do we do to implement those? So those are some critical issues that the court didn't get into. But while some of us were thinking about this judgment and also what implications it has, we felt that there needs to be a more deliberation around these issues among the civil society groups and people and communities who have been working on these issues, especially on what is a river. So what you see on the screen is something that people came out collectively around what is a river. I know what are the rights, what are the duties, and how do we move forward on some of these things. I think through deliberations, what was very interesting was specifically what emerged as the rights of rivers and right to flow unhindered, meander, flooded floodplains. I think one of the questions that has been raised at the chat box is about whether river flooding would be considered as a violation of rights or its duty to not flood. But flooding its floodplain is very essential to river, and they do it. Then it was also about whatever determines the health of the river, and something that the third one, which is a participant from the Northeast India, a lot of communities that relate with it, is that the river has a right to flow, to play, and to feed. And the articulation that we don't usually find when we are defining the rights, but this is also very crucial to the definition of rights, bringing in local communities, indigenous communities, cosmologies into this language. And of course, Universal Declaration of Rights of Rivers is also a very good document to look at what rights would mean. I think for us, one very important aspect is the implementation. We need a democratic system of custodianship, not one where the state is the only actor in the process of custodianship, because we know that the state has been the one who has actually been sponsoring a lot of destructive projects on the rivers. So I need a more consultative process where the local communities are at the center of much of decision making, which of course with other relevant government agencies, civil society groups, and other actors also being involved in the process. We can get more into detail of what this would mean, but possibly with the shortage of time, we can explore this later. The other aspect which is very important, and especially this movement now, which is emerging so rapidly across the world, there's also a sense of or a danger of co-option, and henceforth it is very important to clearly articulate, at least for the movements and groups and networks here in India and some in South Asia as well, that we clearly articulate what we are up against. So for truly to recognize the rights of nature. So we are saying that the current development model that fetishizes on the growth is not the model that we can continue with. So we are questioning that. We are questioning a centralized political governance model that doesn't empower the local communities. We are also questioning the legal framework currently, which is very property oriented, still in much of a colonial Western framework. So we are questioning that as well. And going beyond rights. So we're not saying that the rights of nature is going to solve all our problems and also going to transform all our systems. It's a way towards an end. It's a means towards an end. It's not an end itself. So just coming to the last slide of what lies ahead for us, especially in South Asia. There is something that we need much more awareness, campaigning, and advocacy of what you know, especially in the Indian context. When this judgment was passed, it was primarily from the High Court. There was no local civil society action or people approaching it. The petition was around pollution, and the court actually went way beyond its ambit of granting rights to rivers. So how can we build in local processes and people really relating it to in actually their own languages. So we are also thinking of petitioning the Supreme Court. A lot of legal policy strategies that exist at the global level could also be used, which also includes international law. The customary and traditional law, which up till now has mostly been ignored, but the relationship needs to be studied more, and something that as an alliance we are looking to building more on it. Of course, we need so much more work through education and cultural and other modes, and that is also something we're looking forward to it. And the last point I think is very crucial, especially from an ecological point of view and a regional collaboration point of view as well, is that we have to reimagine this governance from an ecological point of view, eco-regions or bioregions. And that is why we have been stressing on looking at these rights from a regional level, and rather than focusing on nation state levels. So what it means to grant rights to river Indus only in India, but it's going to impact Pakistan, China, all of it. And can India continue to build dams and barrages that impact Bangladesh? So it is important to look at these issues from a regional perspective, and henceforth regional collaborations and work is very, very important. And henceforth Rights of River South Asia Alliance has been formed post the dialogue to actually look at these issues in a much more comprehensive manner and move forward with that regional perspective in mind and regional collaboration. So I will end now. Thanks everybody for listening, and back to you, Amrisha.
Thank you, Shrishti. Thank you for the wonderful presentation. I think it's flowing along well from global perspective to international comparison to South Asia, and now we are moving towards the Bangladesh now. And I think it's fair for me and you to say that India is expecting courts to do everything what a state can't. Since we are both from India, I think we can say that. Thank you for bringing these things to notice. Let's move ahead. We are running quite towards the end of the session. So we'll take all the Q&As at the end of the session. The next panelist is Mohammed Azaz. I would like to invite you. I'll just give a brief introduction about our speaker, and the floor is all yours, Mohammed. So Mr. Azaz is a Bangladeshi researcher. An activist working on various crucial water, river, environmental, as well as climate justice issues. He is the chairman of River and Delta Research Center. It is a center for experts in the field of river basin management, sustainability, and delta studies. He is leading a research project, namely Dhaka Rivers. He focuses on contribution to conservation of natural resources and water bodies. He is a principal advisor of GBM-based People Network that works for the rights of the basin, people in Ganga, Brahmaputra, Meghna River Basin. Under the banner, Azaz is giving training to the CSOs and support various regional, national, transboundary river-related policy dialogues, events, seminars, and demonstrations. He is also a host of a monthly 1-hour talk show. So for our viewers today, you can join his talk show for taking this conversation ahead. With that, I hand over the floor to Mohammed Azaz, and thank you for joining us.
Thank you very much for giving me this opportunity to talk about our experience globally in global platform. And I'm also thank you our distinguished panelists. They have shared so many interesting and very important issues that need to be addressed later on. That's what we are fighting for the last 1 decade, 2 decades. Let me share my slide first, then I can go for it.
Yeah, there we go.
We can see your slides.
So today I'll be discussing about the re-mainstreaming rivers to advocacy, activism, media, and legal fights. You know, the river Turag is a very much highlighted river locally in Bangladesh as well as globally, because High Court has given a remarkable verdict based on this river Turag. So I'll be talking about Turag river case, And my discussion will be highlighting the overview of the ecology of Dhaka, especially the urbanization and how urban Dhaka has been developed. Then I'll skip because there are time limitations with this. So then I'll be discussing about the current scenario of Dhaka rivers and wetlands, especially the status of this wetland and tributaries and sub-distributary channels related to these 4 rivers of the city. Then we'll be discussing about the role of the civil society, how the civil society made this crucial issue to the government and media for the last 2 decades. Then I'll be discussing about the historical High Court verdict, which was given in 2009 and 2019. And after what we are experiencing, that's very important issues with me. I'm trying to share my views. As you know, Dhaka is very old city from the very 1600 century to round. This city has been developed because of its ecology and its geographical attributes. Why it is ecology and geographical attributes? Dhaka is surrounded by 4 major rivers. We know that Buriganga, Shitalakha, Turag, and Balu River. And this city is directly connected with all the districts of this country, as well as it is also directly connected with the sea also. So through the sea, you know, all the foreign countries and the trade has been developed, and later on the surrounding rivers and the international canals were maintained and kept well, as those were in both commercial and communicating arteries. So this is the reality, and that's why Dhaka was treated as sometimes in the business center, sometimes it was a trading hub, regional capital, later on provincial capital during the colonial era. After that, now it's a prime city, and the nation has 17 million inhabitants in this country. Dhaka has another attribute, you know, that Dhaka was treated, and it was said that it was like a Venice of the East, or the city of canals. As we have 4 rivers, Buriganga, Turag, Balu, and Dhaleshwari, we know that. So, but all these 4 rivers were interconnected through so many canals we had, and these canals have navigability also. So from the recent data, what we found, Dhaka Wasa is looking after only 26 canals, and they said that they have Bangladesh. Dhaka had 43 canals, but from our organizations we have surveyed and we found more than 78 canals. These are actually the tributary canals which are giving water continuously to these 4 rivers. And we also found 3 more rivers. One of the name of the river is the Dolai River, and another was Norai River, another is Pando River. So these 3 rivers has been lost because of massive urbanization and massive earth filling on this on the river and the water body. So this is an alarming scenario in Bangladesh, because for the last 2 decades, we see the rural urban migration has been happening from rural area to urban areas, and the result of this urban migration is the increase of settlement demand. So what the government did, government has so many residential projects, and all these projects has been developed through earth filling of water bodies and wetlands. So this is what we found a big sufferings of the ecology of the Dhaka. Later on, we found the aggressive demand of the land. So the land grabbers and the encroachers, they are grabbing not only the wetlands, they're also grabbing the bank of the rivers. Sometimes they are earth filling and encroaching the rivers itself. So that's why we found 3 rivers have already gone, and in response of that, many civil society movements, many environment movements, they came forward for the last 2 decades. And the environment, the river-based civil society organization in Bangladesh played a significant role in sustainable water management and conservation of the rivers and water bodies. They have effectively engaged and influenced decision-making resources As a result, the media had to take rivers and wetland as one of the leading issues. We found for the last 1 decade, river and wetland was the leading news in the newspaper, leading news in electronic media and the mainstream medias. As a result of that, the government include activists and the CS organization and the regional water dialogue and decision making. Especially we have river related task force. The government has included civil society for the decision making of this task force. From that, in the task force, we raise our voices in the in public and in the platform, in the public platforms, in the bank of the rivers, in the streets. We make a lot of voices, and we found only making and only raising voice is not enough. So that's the experience we found in Bangladesh. So later on, what we did, along with our civil society movements, we went for legal fights. So in Bangladesh, there are a lot of environmental lawyers organizations along with the CSOs. They went for the legal fight, and in 2009, the High Court gave one verdict based on River Turag. High Court says to free the Turag, free from this encroachment and land grabbing, rivers needs to be surveyed. This is one. Second is that they declared the 4 rivers as ecologically critical area, ECA, because the health of the water of this river was very, very bad. The BOD, COD gone very high. Then the High Court said they put up the boundary pillars to build walkways and plant trees. Along with that, High Court also said to establish National River Conservation Commission. Within a very short time, they gave 6 months period time to establish this National River Conservation Commission. So we were quite happy because of this verdict has given in 2009. But after that verdict, there is no differences we found in the real field. So there is after 2009, the National River Conservation Commission has been established in 2014, and we found, in spite of this verdict, we found the river grabbing and the river pollution has been aggressively increased. So based on that, the government has started surveying these 4 rivers, and after that they put pillars to demarcate these rivers. And we found the more than 6,000 demarcation pillars has been installed in a wrong area, wrongly installed. That means they have installed within the river. Sometimes they have saved all these land grabbers. That's why you can see the pictures here. The wrong demarcation pillars have been installed to legalize the land grabbers. Encroachment drive has become a cat and mouse game, actually, because the corruptions in the government bodies, in the government organization, their pollution increases continuously. And very important thing is Turag is a 76-kilometer long water channel, but it is catchment area is 1,063 square kilometer. And the one Srishti said, actually what the river should be. The government sees river is nothing but a water channel, but we see a river should be treated as through his basin base or catchment area base. So when the government is taking any projects, so they are considering only the water channel, which are actually functional in the lean season, not even in the monsoon season water channel they're considering. So once we are considering only in lean season water channel, that means you can actually killing the river itself. So all the government projects that has been taken so far are actually killing the rivers. Along with the river morphology of the river structures, we found riverside communities were excluded in projects. This is one. And 3 fishermen villages, which are along with this Turag river, we found they are getting unemployed because of massive river pollution. There is no fish species, fish and other aquatic species living in this river. And the tributaries and distributary channels, the one I said, I found more than 78 tributary channels which are connected to these 4 rivers. So once these projects are undertaking, all these tributary channels and distributary channels are not taking into account. So that is why the encroachment on these tributary channels are going on, and no one is raising any voices for that. So in these circumstances, Civil society and the activist voices triggered and relevant stakeholders of the judiciary to come up with the landmark judgment, the judgment they gave in 2019 that the Turag River got the legal personhood and declared all rivers in Bangladesh to have legal protections. Along with this High Court directives, the High Court gave 17 more major directives for addressing river pollution and illegal riverbank development, as well, especially encroachment. Legal personhood declaration of all rivers in Bangladesh and how far to wait for the legal protection. So we found that safeguard of the natural resources in our Constitution gave the safeguard of the natural resources, biodiversity, wetland, forest, and wildlife for the present and future generations citizens. High Court also acknowledged this thing, but the core outcome, I know we found 17 directives and to empower River Conservation Commission as the legal guardian of all rivers. But what we found in the reality, we found in the reality is the custodianship appears ambiguous because the role and the power of the National River Conservation Commissions in Bangladesh is questionable because they have only one power to report, not more than that. So National River Conservation Commission is basically publishing some reports based on some river facts that what they're getting from the field and newspaper. So, and those who are involved with National River Conservation Commission, they were government officials before. So once they were government officials, some of the government officials, they were working in other departments, whose department were directly involved in cleaning rivers. So now they have transferred to this, once they are transferring to the National River Conservation Commissions, they don't have any mindset of working in favor of this National River, in favor of the river. So this is another important observation we found, and that's why we say choosing an inappropriate guardian for rivers simply make the whole exercise a self-defeating one. River Conservation Commission has established in 2014. Now this is 2021. Not a single case has been sued by River Conservation Commission in favor of any river in Bangladesh. We found NRCC gave only published only two reports, a big report. We really appreciate that in 2018 and 2019. After that, 2020 gone, 2021 is running right now. It's almost end of 2021, but there is no report has been published from this National River Conservation Commission. So it's a very questionable thing that we have a legal entity, we got a legal entity, we got a legal guardianship, but if this guardian has no power and if the guardian has no people's representation, that means what's the point of having a legal guardian for the river? So that's a big question that we are suffering here. In addition to recognition of legal personhood to rivers, there is a indications of legislative reforms, you know that, so from the directives of the judgment. So we haven't got this yet. As time is very short, I am skipping this slide. Another issue that Srishti also raised, that is as half of Bangladeshi rivers water flow dependent on transboundary waters. And the judgment gave in Bangladesh is not applicable for the transboundary water. So what will happen for the rivers, how the rights of the rivers will be secured in the case of transboundary waters? That's a big question, because there is no arrangement we have signed so far with India or any other global platforms. Bangladesh, India, China haven't been signed in UN Water Courses Convention also. So that's a big thing, that how we can treat free flowing rivers. What will be the rights of the free flowing rivers and other rivers? So this is important. So the voice is only useful when it has the power to be heard. Law is not enough. We say every actor, including the government, industry, society, have a role to play in restoring and protecting river system. And it should be done locally as well as it should be done globally, because most of the river basins, more than 145 countries are sharing transboundary river basins. So that means if you want to secure rights of the rivers, you have to address these transboundary river basins also. I'm completing my presentations here. Thank you very much for giving me the opportunity to talk. We'll discuss in the question and answer session later on. Thank you.
Thank you, Azaz. Thank you for the wonderful presentation. And I can see most of the problems India and Bangladesh are facing are similar. And the rights are recognized, but they are not implemented. You have the guardians appointed, but they don't have teeth or enough power to implement the same. And the holistic approach is missing all over. So thank you for pointing all those things out. We will move to our last participants, the youngest member of our panel. And I apologize in advance if I pronounce your name not right. So I welcome Kulirimi Prati. He is a PhD candidate in law at the Institute of Law and Politics of the Santa Ana School of Advanced Studies, Italy, Pisa, and a member of Center for Interlegality Research. Mr. Prati, floor is all yours. And do let me know how to pronounce your name. Thank you.
Well, you got it right. It's Guilherme Prati. It's almost pretty much almost there. So I'm gonna share my slides, and I'm gonna power through the presentation so I can manage to do so in 10 minutes, 10 minutes 30, but I'm gonna power through. Please bear with me.
Slides are visible, not a problem. Please go ahead.
Oh, so first, I'd like to thank Dr. Pandey and all the IWRA staff that are working behind the scenes for putting together this event, and for giving me the opportunity to come here today and present a part of my research alongside the high-level speakers we've had here so far. So what I'm going to try to do here today is to offer a mosaic of the present time Brazil is living in order to show, or at least hint at, how the main topics of this webinar are entangled in the national situation. And I will do this as an effort to outline the context in which the climate litigation is developing in and from. So this should take me the initial minutes, so let's jump right into it. And I'd like to start by answering the question in the title. Is it enough? Well, no, it's not enough. And although it might sound obvious, because if litigation comes from the failure of states, private and public actors to properly act against the climate crisis, well, then I guess it's safe to say that no amount of litigation will ever be enough to rectify that. But this is not the only reason why litigation is not, and I believe will not be enough for Brazil. And this brings me to the hard task of quick commenting the current hydrological crisis the country is facing. Well, in many ways, Brazil is a country full of paradoxes, and I'd like to explore one of these now. For instance, the country has 12% of the world's freshwater resources and 53% of South America's water surface. And yet, the country is living the worst drought in 90 years, the second since 2014, the third since the beginning of this century. Well, and this is a decisive threat for national energy production / energy independence, because more than 60% of energy production comes from hydroelectric power. And a recent research done by the Map Biomes project showed that from 1985 to 2020, Brazil lost more than 15% of its water surfaces. And this is mainly due to deforestation and related activities happening throughout the country, and nowadays, in the last decade, especially in the Amazon. And this is devastating for the region's hydrological cycle, because the Amazon trees pump massive amounts of water from the ground into the atmosphere through a process called evapotranspiration. And here in the chart, you can see how this phenomena unfolds. So the water vapor here from the north gets pushed to the southern region of South America, not just Brazil, but South America. And this phenomenon of pushing water vapor through the air, it's known by the interesting name of flying rivers. And as I said, this is devastating for both the region's hydrological cycle and for national energy production. Because as you can see here in the screen, the vast majority of hydropower plants are concentrated, are located in the southern regions. Well, I have selected two pictures just to break the dry data here. Two pictures taken by the world-renowned Brazilian photographer Sebastião Salgado that show these two phenomena, the evapotranspiration and the flying rivers taking place. So here you can see what the evapotranspiration looks like. This is in the middle of the Amazon, and here you can see what a flying river looks like. In the background, it's one of the biggest mountains in the country called Mount Roraima, but you cannot properly see it because there is a flying river in front of it. But now, since both phenomena, both evapotranspiration and the flying rivers, are at risk, also the frequency and intensity of the rains in the south are at risk. And at the current moment, the reservoirs are struggling around 10 to 20% of their capacity. And this deleterious process is being fostered by the current federal administration since its beginning in 2019 through its consistent and systematic attacks against the environmental and climate protection structures. Alongside these attacks, this administration is also permanently turning the blind eye and looking the other way when it comes to illegal activities happening not only in the Amazon, but in all national biomes. And this has set the country's environmental and climate protection efforts decades back, which brings us to the current climate litigation experience, which has been so far a very particular one. And I say particular one because while elsewhere, the climate litigation is trying to push forward the climate and the environmental agenda, the Brazilian experience is at the moment mainly trying to avoid and or undo the recent dismantling of national structures that are focused on said agenda. And this fact can be seen by the great amount of cases that have been brought against the acts and omissions of the current administration that is going on the opposite direction of the world when it comes to the climate agenda. So just at the Brazilian Supreme Court, I have managed to identify 8 major cases that have been filed since 2019. And here in the first, in April 2019, this government issued a decree that practically extinguished civil penalties and administrative fines in cases of environmental harm. So a few days later, a political party filed a case against it, stating, and I quote, "This decree meant total amnesty for environmental destruction." A year later, the same decree generated yet another case filed this time by 5 political parties. And they stated, and I quote, "The never-ending midterm procedures created by this decree completely paralyzed all national sanctioning procedures in environmental matters," unquote. In August 2019, during the fires that took over the Amazon, the government did not act, did not apply the current existing normative framework in matters of controlling deforestation fires. That generated yet another case filed. And at the time, the pictures of the fire were shocking the world on a daily basis. A month after, September 2019, the general prosecutor issued filed a case against another decree that reduced the amount of seats of civil society at the National Environmental Council. It not only reduced the number of seats, as it also changed the selection procedures for them. A year after that, the newly composed National Environmental Council issued an internal resolution dangerously lowering the national standards for national protection standards for areas of permanent protection. June 2020, 4 political parties filed 2 different complaints regarding the so-called Amazon Fund and Climate Fund, which are national budgets to implement public policies of environmental and climate protection, because the government, this administration, completely strangled, frozen completely froze the budget of both funds. So activities that depended upon them were frozen during the time. In the Amazon Fund case, there is a powerful statement, and I quote, "The government imploded all national environmental programs, and the Amazon Fund was one of the first," unquote. By November 2020, and I'm going to the end, 7 political parties filed a huge case asking the Supreme Court to oblige this federal administration to implement the already existing normative framework when it comes for preventing and controlling deforestation in the legal Amazon area. And they based their complaint in the steady and aggressive growth of deforestation in the Amazon between the years of 19 and 20 when compared to previous years. So in a personal opinion, I would say that even though all cases are based in the right to a healthy environment recognized by the Brazilian Constitution since 1988, these 2 cases stand out from the others due to the way they were argued, and I'll gladly get back to them in the Q&A. Or in the Q&A, I can also mention a little bit more. These 3 cases that were filed outside the Supreme Court, but are symbolically spread throughout the whole country. Well, for my final remarks, and with this I conclude, I'd like to stress one more time the fact that Brazil is a country full of paradoxes. As I said, more than 60% of its energy production comes from hydroelectric power, which is known to be a renewable resource. Well, since we're destroying the region's hydrological cycle and rapidly losing water surface, I guess the word renewable will soon stop applying. And one of the reasons for this, as the cases I highlighted showed, is because Brazil is running at full speed in the opposite direction the world is moving to when it comes for environmental preservation and climate acting. All the while destroying what could be its passport for the future world that is slowly developing before our eyes. And as I stated in the beginning, in a scenario like this, no amount of litigation will ever be enough to rectify this. And on a less and personal note, I'd like to mention that today, September 7th, is the 199th year of Brazilian independence. And this important event, as one can verify in the first verse to the national anthem, happened at the margins of a small river. And symbolically speaking, almost 200 years later, Brazil is about to risk or maybe lose a share of its energy or energetic independence due to lack of proper care of its water resources. And with this, I conclude. If anything was not clear, please do not hesitate to ask or to write me. You can find my email in the red bottom of the slide. Thank you very much for your attention. Thank you.
Thank you, Guleri. Thank you so much. Indeed, your presentation is full of paradoxes, and it's shocking to know a country we know as resource rich is facing these kind of issues. We are running quite short of time, and we have a lot of great questions with us. So I'm just going to jump and take few questions. The first question is directed towards Professor Knox. We have 2 participants, Andre and Seema. They are asking first, where do we sign for right to healthy environment? And second, with respect to human rights to healthy environment, do we also have set of human rights obligations? And if so, how do we implement them?
So where do you sign up for a human right to a healthy environment? Is that the first question? So actually right now, this month of September, the United Nations Human Rights Council, the main United Nations human rights body, is considering whether to recognize for the first time formally at the global level the human right to a healthy environment. And over 1,000 civil society organizations and many individuals have joined a joint letter calling on the United Nations to take this step. So, if you do a search for this online, you should be able to find it, and you should be able to find ways of adding your voice to that if you want. Now, of course, at the national level, many countries already have this right. So you might want to look for organizations that are already trying to implement it, because obviously implementation is a huge problem, as we've heard in many countries. In terms of obligations, corresponding obligations, under international human rights law, the obligations that correspond to human rights are nearly always held by states rather than individuals. Now, there is an increasing effort to hold corporations, another type of legal person, responsible for their own abuses of human rights. Often they're held responsible under, again, national law, but at the international level, for example, there's a treaty being negotiated right now that would set out clear rules for corporations. Corporations do have some standards that apply to them. That's a little bit more complicated topic than I can get into right now. But corporations do have standards that apply to them under what's called the United Nations Guiding Principles for Business and Human Rights. But individuals generally do not. And there are good reasons for that, I think. International human rights law is more focused on states, and they're reluctant to set out obligations on individuals because, frankly, governments would then use that as an excuse for not carrying out their own obligations. You know, we don't have to protect you until you agree to carry out your obligations towards us, which is obviously very problematic. So I hope that answers the question.
Thank you, sir. Thank you so much. So the second question is directed to Dr. O'Donnell. The question is quite tricky, and I know you have some experience in that, and other panelists, please feel free to join in whenever you like. The question is like this: do you come across the responsibility of rivers since it is considered as a living or a legal person? So do you come across any sort of cases which calls upon responsibility of rivers as such?
So that's a really good question, because for many people, when we start thinking about rights, we then immediately think about, well, what are the duties that flow along with those rights? If a river has rights, then it must have corresponding duties. And it feels like those are sort of mirror images or two sides of the same coin. There hasn't been a case yet in the world where the river has been found to have responsibilities as a result of a lawsuit. But one of the drivers for the nominated guardians in Uttarakhand to appeal that decision to the Supreme Court was a concern that they might be held liable for the future flooding of that river. So we haven't directly imposed or found any rivers to have those responsibilities, but it's already influencing, the fear of those responsibilities is already influencing the way that the guardians are certainly thinking about it. One alternative way to think about this, instead of focusing on this question of rights and responsibilities and whether or not a river has duties, is to actually reframe it and to think about it in terms of mutual obligations. Maybe we owe obligations to each other. Maybe we are mutually interdependent and interconnected. And maybe the river needs us as much as we need the river. And if we see it through the lens of obligations, that's I think a much more sensible way to make sense of our relationship with the river, rather than to try and continue to shoehorn the river into this really adversarial, very Western way of understanding legal rights and duties, which is to say, well, these are my rights and these are your duties, and then we'll fight about where the line is drawn between us. Maybe we're in a relationship, we're interconnected, and there's give and take, and there's reciprocity between us. And I think that's a more helpful way of thinking about it.
Thank you, ma'am. So I have a follow-up question to this. Since this is talking about responsibility for rivers, does this somehow relate to the parallel or competing right when rivers are given right to protect themselves? The object of protection of river is somehow subsumed or taken away. So does this correspond to that in any manner?
So it definitely can. When we start seeing rivers as having duties, which we can then require them to fulfill, we can start thinking about, well, maybe it's not about what I owe the river or what I'm doing to the river. Maybe it's about what the river's done for me lately. And that completely changes our relationship back into this one of extraction and demand on the river, rather than thinking about maybe what we owe the river or what our relationship brings both of us, how we rely on the river. So I think that kind of adversarial nature of it, that figuring out how can we use the law to hold the river to account And I've spoken about rivers having rights in lots of different forums over the past 4 years since rivers started to really hit the headlines. And it absolutely astonishes me how quickly people go to that kind of question of, can I sue the river when it floods me? And that's, to me, that's a terrible, terrible signal that people hear about these rights of rivers and then that's their first question, is to go straight into that adversarial relationship. So I think focusing in on this stuff it's a two-edged sword. It's really, really important when it comes to questions of enforcement and force and effect. You need to know what the legal powers are and what the law says the rivers can and cannot do, or what we can and cannot do to the rivers in order to actually enforce that. But if we focus solely on that and we forget about the relationship side of things, then we are at real risk of going backwards.
Thank you, ma'am. Thank you. So narrative is important when we talk about rights and responsibilities. Thank you. There is a comment or general query by Francisco. He says, since we are talking about ecocide, why not extend the duties or obligation to non-state actors as well, even though it is in a predominantly stage and we don't have a concrete definition or anything? Anybody would like to take that question?
I can clarify that.
Yes,
Ecocide would be extended to non-state actors. I mean, maybe I should have been clearer about that. When I said international human rights law generally sets out obligations against states, that is not the case for international criminal law. And so the proposal for ecocide would add a new crime, and that crime, like other crimes, would be directed at, it would be aimed at non-state actors, individuals. Now, those individuals might commit that crime in the course of their work for the state, but they would be prosecuted and punished in their individual capacity. And that would be true as for ecocide too, at least as it has been proposed.
thank you. We are running quite short of time, so we will just take 2 more comments or questions and we'll finish this session for today. So there is one general comment, if anybody would like to comment on it, from Mr. David Hubbard. He says in the current World Water Week, there was no representation for rights for nature. Is this being sidelined outside the academic discussion? And how do we feel about it?
So I was really sad to see that question. I spoke about rights of rivers at World Water Week, back in 2018. So it's a little sad to see that it hasn't continued to flow through. I think when people ask about the impacts of rights of rivers and has it actually, has it turned things around for rivers yet? The answer is actually no, it hasn't. And so I think that's possibly one of the reasons, is that we haven't seen a major upheaval in the way that we manage rivers in response to their recognition as persons. But I think what is missing from that understanding, and I just read an article today that's published on Global Water Forum about the way that Indigenous peoples were presenting and were spoken about at World Water Week. And this person had gone to 4 sessions. There are only 4 sessions that were talking about Indigenous people's rights. And I think that's the missing connection here. Rights of rivers make a lot more sense when they're seen in this pluralistic context of the recognition of different ways of seeing the world, different laws, different understandings of the relationship between people and rivers. The response to recognising rivers as persons is a distinctly, it's a response that is driven by Indigenous leadership. In many cases, it's also a response that occurs in settler colonial countries. So not exclusively, obviously, but that is a big part of the conversation. And I think what we're seeing is a sidelining of this relational understanding of the world. And I think that's the gap that is probably occurring at World Water Week and within the water sector more generally.
Thank you. So this brings us to the last question of the evening. And I'm combining this question by few of the people who are asking different things. So it's broadly, what does river mean? So how do we define river? Can we incorporate underground water, the communities which live on those rivers and that surrounding atmosphere or ecology as such in river? So how do we determine what river is? And then the question of law and policy and everything else is dependent on it. So how would you like to pursue this? Open to the floor.
So if I may take that question.
Please, Shrishti, go ahead.
Yeah, so I think although I've tried answering that question in the chat also, but just to say that I think definition of a river from many perspectives, diverse perspective is needed. One is, of course, emphasizing on how communities define rivers. So for many communities, river is moisture in the air, but it is also what starts from the glaciers. It is basically a whole civilization. So it's so much more broader than water source from one point to the other. Given that, I think it is also to look from different perspectives. I think it needs to be also informed from a scientific perspective, not dominantly from a scientific, Western scientific perspective, but also needs to have that perspective too while we are defining the rivers. One thing about the groundwater, which has multiple times come in the chat also, I think it is important because usually in our popular imagination, rivers only originate from the mountains or from the glaciers. But there are many rivers, we know at least in India, and I'm sure in other parts of the world as well, there are rivers that have been flowing only under the ground. They've originated under the ground and they flow under the ground. They never come up. So are they not rivers? And the communities dependent on them are also, dependent so much for the access and for whatever recharge, how they recharge the springs. So I think that is also an essential element to look at, that when through visible eyes we see certain rivers and we see certain ecosystem, does that only become rivers, or it's much more than that? And I think for, again, many people, groundwater becomes essential to the definition of a river. And also the communities. So largely what we see in, say, the Indian context, local communities were completely out of the picture, as if they are the encroachers. And we have seen with a lot of pro-environment acts that local communities become either the encroachers or people who are polluting the river, but not seeing the relationship of whole sacred and secular institutions that we have and how really the communities relate to the river. So they need to be part of those decision makings, and also in the conceptualization of what is a river and what are the rights of the river as well. Yeah, thanks, Amisha.
Thank you. Anybody else? Azaz, please go ahead.
Yeah, if I may add from our experience. So along with Srishti, what she said is absolutely right, and we also agree on that. But along with that, we find as we are living in the lower reach of two mega big rivers like Ganga, Brahmaputra, and Meghnad. So in the lower reach, there is a issue, and reality is the floodplains and flood-prone areas. So if we consider only water flow or only catchment areas, and we exclude these floodplain areas from, if you exclude it from the rivers, then this is dangerous, because in the lower reach, floodplains are very important and in the key, because floodplain contains 40% of the global species habitat. This is one. And second thing is rivers are getting sourcing water from the floodplains in the lean season. So if we have to consider floodplains and floodprone areas as a part of the river system. That is very important here in Bangladesh, I think. Thank you.
Thank you so much. Thank you, everyone. And I apologize for exceeding the time by 15 minutes. I would just again like to thank you all for coming together to talk about this issue. And it has been a wonderful session. I hand over the floor to Scott for concluding remarks. Scott.
Well, thank you so much for that really great presentation to everyone, and for that really great job moderating, Dr. Pandey. We really appreciate that. Did a great job. I think we were able to address everyone's questions today, but if we haven't had a chance, feel free to try to reach out to anyone on the panel. Everyone's email addresses that are public, and post your question that way, particularly if you want to follow up and learn more. And that'd be a good way if you didn't get your question answered. But I think we did a good job of getting everyone answered. So thanks everyone for sticking around. So again, I'd like to thank the panel for just such a great webinar. So Dr. John Knox, a professor at Wake Forest University, Dr. Erin O'Donnell, a fellow at the University of Melbourne in Australia, Shirji Banjbi, founder of the Rights of Rivers South Asian Alliance in India, Mohammed Aziz, Chairman, River and Delta Research Center in Bangladesh, and Guilherme Prati, a PhD student at Santa Ana School of University Advanced Studies in Pisa, Italy, and of course our great moderator, Emrich Prati, Assistant Professor of Law at Gidget Maritime University. So I really hope everyone in the audience found the insights provided by our panel during this special event to be useful. And I really hope that they're going to generate a lot of creativity for your own work, whether it's academic or professional, practitioner at the same time. So if these presentations have left you interested in learning more, please go to our LinkedIn webpage where you can continue the discussion. And you can follow us at IWRA on Twitter as well. So if you're interested in learning more about the association or becoming a member, please go to us at www.iwra.org. And as a reminder, we'll have all the presentations and a recording of this event in its entirety on the website in a few days. So on behalf of the whole IWRA office, thank you for viewing this webinar. Thanks.